Lukumbi nange nikola nsimba ku mata sirikazirira nfune ku mata nkugambye kapana ava ku basimu ava ku basimu antamana okwogera yakwogera panange jengeri yagala owapije fakiti yagala kunkubirako luseke wanange mukiriza musindike kooti etandise tetusobola kwogera kati kooti etandise
we never filed an application to reply, I'm grateful, beautiful, to reply to the application. We don't proceed. Your Worship, the applicants made an application under Article 23, 6C. Don't mention your colleague in Pangola, the value section, Article 25. It is your report for saying Article 25. It is Article 26. I can't keep for the correction. No worries. Their argument is that the applicants have been on remand for over 6 months. And they are premising their argument on the charges under the General Court Martial. Where the first two applicants, that is Lieutenant Colonel Dr. Chiza Besigye and Haj Obed Lutale, appeared on the 20th of November 2024. The defense or the applicants are also relating the same to the charges that the applicants are facing before this honorable court. Article 23(6)(c), which is the basis of this application, is to the effect that where a person is arrested in respect of a criminal offense, and in the case of an offense trial only by the High Court, if that person has been remanded in custody for 180 days before that case is committed to the High Court, that person shall be released on bail on such terms as the court considers reasonable. This article is perfect. However, it doesn't apply in the instant case. Why? The applicants appeared before the General Court Martial. On charges which are triable, not only by the High Court, but the lower court. That one collapses the application because the article is very clear. Only, let me repeat it, if that person has been remanded in custody, in the case of an offense triable only by the High Court, the charges the applicants were facing before the General Court Martial were not offenses or charges that fall under Article 23(6)(c) of the Constitution. In other words, it is only the charges which the applicants are facing before this honorable court that apply under Article 23(6)(c). This is a total misinterpretation of the Constitution by the defense. The applicants appeared in this court, which I may refer to as the civil justice system, on the 21st of February 2025. And this is the legitimate charge which this honorable court has jurisdiction over on the 21st of February 2025. That said, even if the applicants were facing charges that are referred to under Article 23(6)(c) of the Constitution, the charges of the General Court Martial do not apply in this honorable court, because the court martial is under military justice system. And this court does not have powers on any matter that is before the General Court Martial. The same applies to DPP, the Director of Public Prosecutions, whom I represent today. So it would be irregular to bundle the two justice systems and hold the civil justice system liable for, actually responsible for what happened in or before the military justice system. As if that's not enough, the charges under the General Court Martial ceased and were terminated by the constitutional ruling of the Supreme Court. In other words, DPP never inherited any charges which were instituted before the General Court Martial. DPP initiated or directed for fresh and new investigations, which are the basis of the charges that the applicants are facing. The applicants furnished this court with a copy of the charge sheet, which was before the General Court Martial, and I believe this court takes judicial notice of the charges on the charge sheet, apparently for court. And if that is the case, court may realize that the charges do not speak to each other. The General Court Martial has different charges, there are different charges, and here the applicants are facing charges which are completely different. But even if the applicants were charged with offenses which attract death, even if the applicants were charged with offenses which attract death before the General Court Martial, the civil justice system where this honorable court falls does not have jurisdiction and does not enforce the UPDF Act under which the applicants were charged. So that makes the two completely different. Your Worship, the question is, does this court have a record of the General Court Martial? And if it is true that it does not have the way I believe, then this court, where does this court get the moral and legal authority to be bound by proceedings which are not before it? We invite this court agree with the prosecution that this court does not have any moral or legal authority to consider the record of proceeding in the General Court Martial, even if it had it, because this court was not party to that. This court did not in any way inherit the proceedings of the General Court Martial. And I beg also question, ask again. And I also ask this court, ask itself, when did the charges against the applicants, when were they filed before this court? When did this court first interact or come into contact with the applicants? as a civil justice court. It is simple mathematics. It is on the 21st of February 2025. And that translates. What does that mean? Lawyers are not good mathematicians, they do not count money, but I try to count. The applicants have been in custody for 3 months and 8 days. So they have been, before, they have been on remand not more than 4 months. To put it that way, generally. Now, if that is the issue, if it is true, they have been on remand for not more than 6 months, are they entitled to the provisions under Article 23, Law 6C? The answer, your worship, is in the negative. No. And if that is the issue, the other question is, was this a misinterpretation of the provisions of that article by the defense? We beg this court to answer it in affirmative. Your worship, we do appreciate the provisions of that article, and we would have no problem court releasing the applicant if they had blocked the mandatory thing. But they have not. This court would have assumed the jurisdiction which is over and above that it has in the civil justice system. My brothers quoted several authorities in that regard. They quoted so many cases. It is a submission that prosecution agrees with the defense that this court is by law supposed to protect all the rights of the applicant before it. But court should not also have this matter handled on the matter of technicality, as it was submitted by my colleagues under Article 126(2)(e) of the Constitution. Even if the applicants, for example, if I'm to play a devil's advocate role, even if the applicants had clocked mandatory, prosecution duly noticed, put the defense, the applicants on notice that they are ready to commit the applicants. They are on notice. That mere notice ties up the hands of this court. It is our submission and prosecution that ties up this court. And any decision which is to the contrary would be administering substantial injustice on a matter of technicality. How? Because the defense submitted that Article 23, Clause 6C applies instantly, and that court cannot do anything else for as long as the accused person or the applicant blocks mandatory period. Our argument is that even if they had blocked mandatory period, the mere fact that we put them on notice that our committee papers are ready, the provisions under Article 23, Clause 6C is not a ticket to have the applicants released on mandatory bail when the committee papers are available. Because the issue then is, what is the substantive justice here? The substantive justice here is to have an expeditious trial of the applicants, which can only be done after being committed to high court. The argument by defense that, the first thing we have to do is to consider mandatory bail, let the applicants be released on mandatory bail, then the rest come later. That is the thinking selfishly. It is acting contrary to Article 126.628, which they quoted. Gosh, they took a lot of time. In fact, I was just about 10% of the 10 minutes. So it is a submission, Your Worship, that this court disregards and dismisses the application by defense on the basis that this court has no control over matters for general court martial. They have not blocked mandatory period of time. The fact that they were remanded on the 21st of February 2025. Because this application, Your Worship, is in bad faith. It is in bad faith, especially given that the committee papers are available. We are ready to commit. We have been on record several times, and we have submitted that defense has been arm-twisting prosecution to delay the prosecution of this matter by using all the tricks available, all tricks that are actually at their disposal to ensure that they frustrate the process. They should have been the people who should be agitating for an expeditious trial. But now they are speaking the other language. Because as prosecution, we believe that now that our committee papers are ready, it doesn't make sense to have the applicants released on mandatory. It is our prayer that the accused persons or the applicants be committed and have the matter expeditiously tried, because we are ready. We beg this court to dismiss the application. They are tempted with that in this application. So,
I'll make my response first and then my colleagues will come in. I'm just we will try and be very short. One of the things is, when does the period of remand count? And I'll start by giving the court an authority which was determined in April this year by Justice Isaac Mwaka. This is application number 133 of 2025, arising from criminal number UPDF DCM 022 of 2020. Besigye applicant versus Uganda. And in this case, I will not go to the details, but I'll come to the end of it, where the court says, I find that the applicant has satisfied the requirements for mandatory bail and Article 23(6)(c) of the Constitution, Section 15 of the Trial on Indictments, case detention of over 1,500 days without trial, and committal qualifies him to be released on mandatory bail. this person, the 1,500 days being referred to, is the remand in the general court, in the court martial. So this authority sorts out the matter of whether the period of remand in the court martial counts. Number two, it would be absurd to construe the period of remand as 3 months. And I'm urging this court to take judicial notice because these matters have been very public. Since the judgment of the Supreme Court on the 31st of January this year, the A1, A2 have been in court applying for bail, and the prosecution has refused to concede to bail. They were not released by the authorities even after the judgment. How then can the court take the period of remand after the general court martial asylum? Before we came before this court, under what warrants were they being held? Wasn't it to the order of the state, which continued to oppose bail application? My friend cannot approbate and reprobate. He must decide what his submissions are, but not one time to oppose bail and say they are lawfully held, and then to come and disown the period for which they were detained as an extension of the proceedings in the general court martial. In fact, doing so is admitting malice, because if there was no connection, then the Attorney General would have been the first to say, release them, we are now doing new investigations. The Attorney General did not do that.